Jurisdiction of Sandiganbayan in criminal cases. Under the 1973 Constitution, the Batas Pambansa was directed to create a special court to be known as Sandiganbayan, which shall have jurisdiction over criminal and civil cases involving graft and corrupt practices and such other offenses committed by public officers and employees, including those in government-owned or controlled corporations, in relation to their office as may be determined by law. Under the 1987 Constitution, it provides that the present anti-graft court, known as the Sandiganbayan, shall continue to function and exercise its jurisdiction as now or hereafter may be provided by law. The jurisdiction of the Sandiganbayan is perhaps one of the most often amended provision from the 1973 Constitution to Republic Act 8249 of 1997, and of course the recent amendment, which we will discuss later. Before RA 8249, the jurisdiction of the Sandiganbayan was determined on the basis of the penalty imposable on the offense charged. Then, it was amended such that regardless of the penalty, so long as the offense charged was committed by a public officer, the Sandiganbayan was vested with the jurisdiction. So under RA 8249, to determine the jurisdiction of the Sandiganbayan, lawyers must look into two criteria, namely, number 1, the nature of the offense, or number 2, the salary grade of the public official. Let's look back at the laws that created and amended the Sandiganbayan law. Presidential Decree number 1486, June 11, 1978, created the Sandiganbayan. Then, Presidential Decree number 1606, December 10, 1978, revised PD number 1486. Then, Republic Act number 8249, Feb 5, 1997, amended PD number 1606. And finally, the recent amendment, Republic Act number 10660, April 16, 2015, amended the Sandiganbayan law. So what are the cases covered by the jurisdiction of the Sandiganbayan? The Sandiganbayan shall exercise exclusive original jurisdiction in all cases involving A. Violations of RA number 3019 as amended, otherwise known as the Anti-Graft and Corrupt Practices Act. RA number 1379, or forfeiture of illegally acquired wealth. Chapter 2, Section 2, Title 7 of the Revised Penal Code, or crimes committed by public officers, namely, direct bribery, indirect bribery, qualified bribery, and corruption of public officials. Where one or more of the accused are officials occupying the following positions in the government, whether in a permanent, acting, or interim capacity, at the time of the commission of the offense. Okay, what are these positions? Number 1, officials of the executive branch occupying the positions of regional director and higher, otherwise classified as grade 27 or higher of the Compensation and Position Classification Act of 1989, or RA number 6758, specifically including letter A, provincial governors, vice governors, members of the Sangguniang Panlalawigan, provincial treasurers, assessors, engineers, and other provincial department heads. Letter B, city mayors, vice mayors, members of the Sangguniang Panglungsod, city treasurers, assessors, engineers, and other department heads. Letter C, officials of the diplomatic service occupying the position of consul and higher. Letter D, Philippine Army and Air Force, colonels, naval captains, and all officers of higher rank. Letter E, officers of the PNP while occupying the position of provincial director and those holding the rank of senior superintendent or higher. Letter F, city and provincial prosecutors and their assistants, officials and the prosecutors in the office of the Ombudsman and special prosecutor. Letter G, president, directors, or trustees or managers of government-owned or controlled corporations, state universities or educational institutions, or foundations. Note that it is not only the salary grade that determines the jurisdiction of the Sandiganbayan. The salary grade has no reference, for example, to provincial governors, vice governors, or members of the Sangguniang Panlalawigan, Sangguniang Panglungsod, directors or managers of GOCC, city mayors, vice mayors, city treasurers, assessors, engineers, trustees of state universities, and other officials enumerated in Section 4, 1A from letters A to G of PD 1606 as amended. The Sandiganbayan has jurisdiction, again, at the time of the commission of the offense, over members of Congress and official thereof classified as grade 27 and up under the Compensation and Classification Act of 1989. Number 3, members of the judiciary without prejudice to the provisions of the Constitution. Number 4, chairmen and members of the constitutional commissions without prejudice to the provisions of the Constitution. Number 5, all other national and local officials classified as grades 27 and higher under the Compensation and Position Classification Act of 1989. The Sandiganbayan has jurisdiction over other offenses or felonies, whether simple or complex with other crimes committed by the public officials and employees mentioned in subsection A of this section in relation to their office. And letter C, civil and criminal cases filed pursuant to and in connection with EO 1, 2, 14, and 14-A issued in 1986. The Sandiganbayan has exclusive original jurisdiction over cases that are not within the exclusive original jurisdiction of the RTC. So under the recent amendment, RA number 10660, 2015, the RTC has the exclusive original jurisdiction where the information A, does not allege damage to government or any bribery, or B, it alleges damage to the government or bribery arising from the same or closely related transactions or acts in an amount not exceeding 1 million pesos. So these allegations must be provided in the information so that the case will fall under the jurisdiction of the Sandiganbayan. Otherwise, it shall be within the exclusive original jurisdiction of the RTC. Now let us discuss the case of People v. Ricarte, criminal case number SB-16-CRM-1088 for violation of Section 3E, RA number 3019, April 27, 2017. So the facts of this case are as follows. Ricarte filed a motion to dismiss dated March 21, 2017 on the ground of lack jurisdiction. He argued that in the information there was no allegation of damage or injury to the government or bribery and trial has not begun, so the Sandiganbayan has no jurisdiction. He cited RA number 10660 as basis of the lack of jurisdiction. Now the issue in this case is whether the Sandiganbayan has jurisdiction over the case, despite the fact of the failure to allege in the information of damage to the government. The Sandiganbayan held that while it is true that Section 2 of RA number 10660, which amended the Section 4 of PD 1606, conferred to the RTC exclusive original jurisdiction where the information does not allege any damage to the government or any bribery, or alleges damage to the government or bribery arising from the same closely related transactions or acts in an amount not exceeding 1 million pesos, the Sandiganbayan said that in Section 5 of the same law, or in the transitory provision, the law provides that the act shall apply to all cases pending in the Sandiganbayan over which trial has not begun, provided that Section 2 amending Section 4 of PD 1606 as amended on jurisdiction, and Section 3 amending Section 5 of PD 1606 as amended on proceedings how conducted decision by majority vote shall apply to cases arising from offenses committed after the effectivity of the act. Okay, in this case, a reading of Section 5 shows that the amendment or transfer of jurisdiction applies only to cases arising from offenses committed after RA 10660 took effect on May 5, 2015, and therefore the said amendment is not applicable in this case as the offense charged against the accused was allegedly committed on or about 2008 to 2012 or sometime prior or subsequent thereto. Okay, the Sandiganbayan does not have jurisdiction if the RTC has exclusive original jurisdiction in this case, where none of the accused are occupying positions with salary grade 27 or higher, or military or PNP mentioned. Exclusive original jurisdiction shall be in the proper RTC or MTCs as the case may be, pursuant to their respective jurisdictions under BP 129 as amended. Okay, going back to the jurisdiction of the Sandiganbayan has exclusive original jurisdiction over petitions for the issuance of writ of mandamus, prohibition, certiorari, habeas corpus, injunction, and other ancillary writs and processes in aid of its appellate jurisdiction, provided jurisdiction is not exclusive of the Supreme Court. The Sandiganbayan has exclusive original jurisdiction over petitions for quo warranto arising or that may arise in cases filed or that may be filed under EO1, EO2, EO14, and 14-A, provided that jurisdiction is not exclusive of the Supreme Court, and other cases provided the accused belongs to salary grade 27 or higher, such as, for example, violation of RA 6713 or the Code of Conduct and Ethical Standards, or violation of RA 7080 or the Plunder Law, or violation of 7659, the Heinous Crimes Law, or violation of RA 9160, which is a violation of the Anti-Money Laundering Law when committed by a public officer. Okay. The Sandiganbayan has the exclusive appellate jurisdiction over final judgments, resolutions, or orders of the RTC, whether in the exercise of their original or appellate jurisdiction over crimes and civil cases falling within the original exclusive jurisdiction of the Sandiganbayan, but which were committed by public officers below salary grade 27. Under the Sandiganbayan law, there is a rule that a criminal and civil aspect must be jointly determined. So, it provides that any provisions of law or rules of court to the contrary notwithstanding, the criminal action and the corresponding civil action for the recovery of civil liability shall at all times be simultaneously instituted with and jointly determined in the same proceeding by the Sandiganbayan or the appropriate courts. The filing of the criminal action being deemed to necessarily carry with it the filing of the civil action, and no right to reserve the filing of such civil action separately from the criminal action shall be recognized, provided, however, that where the civil action had already been filed separately, but judgment therein has not yet been rendered, and the criminal case is thereafter filed with the Sandiganbayan or the appropriate court, said civil action shall be transferred to the Sandiganbayan or the appropriate court, as the case may be, for consolidation and joint determination with the criminal action. Otherwise, the separate civil action shall be deemed abandoned. Now let us discuss different parts of the law. There is a provision providing otherwise classified as grade 27 and higher. Where is it found? It is in paragraph A1. Officials of the executive branch occupying the positions of regional director and higher, otherwise classified as grade 27 or higher, or the Compensation and Classification Act of 1989, RA number 6758. So the phrase otherwise classified as grade 27 and higher qualifies regional director and higher. It is apparent from the sponsorship speech of Senator Raul Rocco on Senate Bill numbers 1353 and 844 which eventually became RA number 7975 and 8249. So the jurisdiction, therefore, refers to certain grade upwards which shall remain with the Sandiganbayan. It was explained that to speed up trial in the Sandiganbayan, RA number 7975 was enacted for the court to concentrate on the larger fish, and leave the small fry to the lower courts. This law became effective on May 6, 1995, and it provided a two-pronged solution to the clogging of the dockets of that court, to wit, it divested the Sandiganbayan of jurisdiction over public officials whose salary grades were at grade 26 or lower, devolving thereby these cases to the lower courts, and retaining the jurisdiction of the Sandiganbayan only over public officials whose salary grades were at grade 27 or higher, and over other specific public officials holding important positions in government regardless of salary grade. In the case of Dancano versus Sandiganbayan, 2nd Division, GR number 191894, July 15, 2015, the Supreme Court held that the legislative intent is to allow the Sandiganbayan to devote its time and expertise to big-time cases involving the so-called big fishes in the government rather than those accused who are of limited means who stand trial for petty crimes, the so-called small fry, which in turn helps the court decongest its dockets. Now, how about salary grade 26? Can the Sandiganbayan have jurisdiction over officials with salary grade 26 or lower? Those that are classified as grade 26 and below may still fall within the jurisdiction of the Sandiganbayan, provided that they hold the positions thus enumerated by the same law. Particularly and exclusively enumerated are provincial governors, vice governors, members of the Sangguniang Panlalawigan, and provincial treasurers, assessors, engineers, and other provincial department heads, city mayors, vice mayors, members of the Sangguniang Panglungsod, city treasurers, assessors, engineers, and other city department heads, officials of the diplomatic service occupying the position as consul and higher, Philippine Army and Air Force colonels, naval captains, and all officers of higher rank, PNP chief superintendents and PNP officers of higher rank, city and provincial prosecutors and their assistants, and officials and prosecutors in the office of the Ombudsman and special prosecutor, and presidents, directors, and trustees or managers of government-owned or controlled corporations, state universities or educational institutions, or foundations. So in connection therewith, Section 4B of the same law provides that other offenses or felonies committed by public officials and employees mentioned in subsection A in relation to their office also fall under the jurisdiction of the Sandiganbayan. So again, these officials enumerated, even if they are not considered as having salary grade 27 or higher, they are still under the jurisdiction of the Sandiganbayan. So, it is clear that those that are classified as salary grade 26 and below may still fall within the jurisdiction of the Sandiganbayan, provided that they hold the positions enumerated by the law. In this category, it is the position held, not the salary grade, which determines the jurisdiction of the Sandiganbayan. The specific inclusion constitutes an exception to the general qualification relating to officials of the executive branch occupying the positions of regional director and higher, otherwise classified as grade 27 and higher, of the Compensation and Position Classification Act of 1989. The Supreme Court held that thus, to cite a few, we have held that a member of the Sangguniang Panglungsod, a department manager of the Philippine Health Insurance Corporation, or PhilHealth, a student regent of the University of the Philippines, and a head of the legal department and chief of the documentation with corresponding ranks of vice presidents and assistant vice president of the Armed Forces of the Philippines Retirement and Separation Benefit System fall within the jurisdiction of the Sandiganbayan. The case of Innocentes versus People, GR number 205963-64, July 7, 2016. The facts of this case are as follows. Innocentes was charged with violation of Section 3E of RA number 3019 as amended. Innocentes moved to quash the information on the ground that Sandiganbayan does not have jurisdiction over the case. He alleged that at the time of the commission of the alleged offense, he held a position with salary grade of 26. He likewise claims that he cannot fall under the enumeration of managers of GOCCs because his position as department manager cannot be placed in the same category as the president, general manager, and trustee of the GSIS. The Sandiganbayan maintained its jurisdiction because Section 4 of PD 1606 as amended by RA number 8249 specifically includes managers of GOCCs whose position may not fall under salary grade 27 or higher who violate RA number 3019. Now the issue in this case is whether petitioner's position as branch manager of GSIS and occupying salary grade 25 is covered by the Sandiganbayan jurisdiction. The Supreme Court held that the applicable law provides that violations of RA number 3019 committed by presidents, directors, or trustees or managers of government-owned or controlled corporations and state universities shall be within the exclusive original jurisdiction of the Sandiganbayan. So, the court said that it has been clarified that the provision of law defining the jurisdiction of the Sandiganbayan has been explained that the Sandiganbayan maintains its jurisdiction over those officials specifically enumerated in letter A to G of Section 4, Paragraph 1 of PD number 1606 as amended, regardless of their salary grades. Simply put, those that are classified as salary grade 26 and below may still fall within the jurisdiction of the Sandiganbayan, provided they hold the positions enumerated by the law. In this category, it is the position held, not the salary grade, which determines the jurisdiction of the Sandiganbayan. Furthermore, as the Sandiganbayan correctly held, even low-level management positions fall under the jurisdiction of the Sandiganbayan. How about the Sangguniang Panglungsod? In one case, the Supreme Court held that the public official involved was a member of the Sangguniang Panglungsod with salary grade 25 and was charged with violation of RA number 3019. In ruling that the Sandiganbayan had jurisdiction over the said public official, the Supreme Court held that a member of the Sangguniang Panglungsod at the time of the alleged commission of an offense in relation to her office falls within the jurisdiction or original jurisdiction of the Sandiganbayan. Section 4B, other offenses or felonies, whether simple or complex, with other crimes committed by the public officials and employees mentioned in subsection A of this section in relation to their office. So what does this mean? The said other offenses and felonies are broad in scope but are limited only to those that are committed in relation to the public official or employee's office. The Supreme Court had ruled that as long as the offense charged in the information is intimately connected with the office and is alleged to have been perpetrated while the accused was in the performance, though improper or irregular, of his official functions, there being no personal motive to commit the crime, and had the accused not have committed it had he not held the aforesaid office, the accused is held to have been indicted for an offense committed in relation to his office. Now, what is the difference between Section 4A and Section 4B? In Section 4A, public office is essential as an element of the said offenses themselves. Example, Anti-Graft and Corrupt Practices Act. Public office is essential as an element of the commission of these or violation of this law. Whereas in Section 4B, it is enough that the said offenses and felonies were committed in relation to the public officials or employees' office. Now let us discuss the case of People v. Sandiganbayan, GR number 167304, August 25, 2009. The Supreme Court cited two cases here. First, Lacson versus Executive Secretary, where the crime involved was murder. The court held in that case that the phrase other offenses or felonies is too broad as to include the crime of murder, provided it was committed in relation to the accused official functions. Thus, under said paragraph P, what determines the Sandiganbayan's jurisdiction is the official position or rank of the offender, that is, whether he is one of those public officers or employees enumerated in paragraph A of section 4. Also, in the case of Alarilla versus Sandiganbayan, where the public official was charged with grave threats, the Supreme Court ruled that in that case, the amended information contained allegations that the accused petitioner therein took advantage of his official functions as municipal mayor of Maykawayan, Bulacan, when he committed the crime of grave threats, as defined in the revised penal code, against complainant Legazpi, a municipal councilor. The office of the special prosecutor charged the petitioner in that case with aiming a gun at and threatening to kill Legazpi during a public hearing after the latter had rendered a privileged speech critical to petitioner's administration. So clearly, based on such allegations, the crime charge is intimately connected with the discharge of petitioner's official functions. This was elaborated upon by the public respondent in that case, the resolution wherein it held that the accused was performing his official duty as municipal mayor when he attended said public hearing, and that accused's violent act was precipitated by complainant's criticism of his administration as the mayor or chief executive of the municipality during the latter's privileged speech. It was his response to private complainant's attack to his office. If he was not the mayor, he would not have been irritated or angered by whatever private complainant might have said during said privileged speech. Thus, based on the allegations in the information, the Sandiganbayan correctly assumed jurisdiction over the case. So in both these cases, the Supreme Court held that they are covered under the in relation to their office. Further, the Supreme Court held that proceeding from the above rulings of this court, a close reading of the information filed against Respondent Amante for violation of the Auditing Code of the Philippines reveals that the said offense was committed in relation to her office, making her fall under Section 4B of PD number 1606 as amended. The Supreme Court held that the general rule is that an offense may be considered as committed in relation to the accused office if the offense cannot exist without the office, such that the office is a constituent element of the crime. The exception is that although public office is not an element of the crime of, let's say, murder, in the abstract, the facts in a particular case may show that the offense therein charged is intimately connected with the accused's respective offices and was perpetrated while they were in the performance, though improper or irregular, of their official functions. Indeed, the accused had no personal motive to commit the crime, and they would not have committed it had they not held their aforesaid offices, just like, as mentioned earlier, the mayor. He would not have committed the crime if he was not the mayor. Therefore, it is considered committed in relation to their office. So what's the meaning of mention in subsection A? The same provision of Section 4B does not mention any qualification as to the public officials involved. It simply stated public officials and employees mentioned in subsection A of the same section. Therefore, it refers to those public officials with salary grade 27 and above, except those specifically enumerated under subsection A. Let us discuss the case of De Lima versus Guerrero. This is a recent case, GR number 229781, October 10, 2017. The facts of this case are as follows. On February 17, 2017, 3 informations were filed against De Lima and several co-accused before the Regional Trial Court of Muntinlupa City. One of the informations charged her for violation of the Comprehensive Dangerous Drugs Act. Well, the Lima filed a motion to quash on the ground that the RTC lacks jurisdiction over the offense charge. The issue in this case is whether the RTC or the Sandiganbayan has the jurisdiction over the violation of RA 9165 in the assailed information. So relating it to our discussion of the in relation to their office, whether or not the commission of such act may be considered as in relation to the office such that it would fall under the Sandiganbayan jurisdiction. Now, what is the ruling of the Supreme Court? The Supreme Court held that the exclusive original jurisdiction over violations of RA 9165 is not transferred to the Sandiganbayan whenever the accused occupies a position classified as salary grade 27 or higher, regardless of whether the violation is alleged as committed in relation to office. The power of the Sandiganbayan to sit in judgment of high-ranking government officials is not omnipotent. The Sandiganbayan's jurisdiction is circumscribed by law, and its limits are currently defined and prescribed by RA 10660, which amended PD number 1606. The Supreme Court held that while it may be argued that some facts may be taken as constitutive of some elements of direct bribery under the revised penal code, the facts taken together with the other allegations in the information portray a much bigger picture, which is illegal drug trading. Under the Comprehensive Dangerous Drugs Act, a plain reading of the law will reveal that jurisdiction over drug-related cases is exclusively vested with the regional trial court and no other. The Supreme Court held that the Sandiganbayan is without jurisdiction to hear drug-related cases. Even Section 4B of PD 1606 as amended by RA 10660, touted by the petitioner and the dissents as a catch-all provision because, it provides in relation to their office, but the court said it does not operate to strip the RTCs of its exclusive original jurisdiction over violations of RA 9165. As pointed out by Justices Tiham and Martires, a perusal of the drugs law will reveal that public officials were never considered excluded from its scope. Hence, Section 27 of RA 9165 punishes government officials found to have benefited from the trafficking of dangerous drugs, while Section 8 of the same law imposes the maximum penalty on such government officials and employees. Okay, to reiterate for emphasis, Section 4B of PD 1606 as amended by RA 10660 is the general law on jurisdiction of the Sandiganbayan over crimes and offenses committed by high-ranking public officers in relation to their office. Section 90, RA 9165, or the Comprehensive Dangerous Drugs Act, is the special law excluding from the Sandiganbayan's jurisdiction violations of RA 9165 committed even by public officers. So in the latter case, jurisdiction is vested upon the RTCs designated by the Supreme Court as drugs court, regardless of whether the violation of RA 9165 was committed in relation to the public official's office. Cases not within the Sandiganbayan jurisdiction. So Section 4B actually provides in relation to their office, right? However, it is only the general rule. There are a lot of exceptions, and as we have discussed, drug-related cases, even if committed in relation to a public officer's office, does not fall under the Sandiganbayan jurisdiction. Okay? What are other exceptions? Besides the jurisdiction on written defamations and libel, the RTC is likewise given exclusive original jurisdiction to try and decide any criminal action or proceedings for violation of the Omnibus Election Code, regardless of whether such violation was committed by public officers occupying positions classified as grade 27 or higher in relation to their office. In fact, offenses committed by members of the armed forces in relation to their office, that is, in other words, RA 7055 or service-connected crimes or offenses, are not cognizable by the Sandiganbayan but by the court-martial. So again, in short, there are several cases that do not fall under the Sandiganbayan jurisdiction. and even they do not fall under the in relation to their office phrase because they fall under other jurisdiction or under other courts as provided by separate laws. Sandiganbayan jurisdiction not solely determined by pay scale. In the case also of De Lima versus Guerrero, the Supreme Court held that certainly jurisdiction over offenses and felonies committed by public officers is not determined solely by the pay scale or by the fact that they were committed in relation to their office. In determining the forum vested with the jurisdiction to try and decide criminal actions, the laws governing the subject matter of the criminal prosecution must likewise be considered. How about private individuals? Can they fall under the jurisdiction of the Sandiganbayan? In case the private individuals are charged as co-principals, accomplices, or accessories with the public officers or employees, including those employed in government-owned or controlled corporations, they shall be tried jointly with said public officers and employees in the proper courts which shall exercise exclusive original jurisdiction over them. What if private individuals are not charged as co-principals, accomplices, or accessories with the public officers or employees? Can they still fall under the jurisdiction of the Sandiganbayan? This is answered in the case of Decini versus Sandiganbayan, GR number 169823224 and 174764-65, September 11, 2013. The facts of this case are as follows. Decini was charged in the Sandiganbayan with corruption of public officials, penalized under Article 212 in relation to Article 210 of the Revised Penal Code, and with violation of Section 4A, RA number 3019. Decini challenged the jurisdiction of the Sandiganbayan on the ground that being a private individual, not charged as a co-principal, accomplice, or accessory of a public officer, he could be prosecuted in the regular courts instead of the Sandiganbayan. So the issue in this case is whether the Sandiganbayan has jurisdiction over the petitioner as a private individual. He was not charged as a co-principal or an accomplice or accessory, but as a private individual alone. The Supreme Court held that the Sandiganbayan has exclusive original jurisdiction over the criminal action involving petitioner, notwithstanding that he is a private individual, considering that his criminal prosecution is intimately related to the recovery of ill-gotten wealth of the Marcoses, their immediate family, subordinates, and close associates. So the Supreme Court held that the Sandiganbayan was vested with original and exclusive jurisdiction over all cases involving paragraph C, civil and criminal cases filed pursuant to and in connection with Executive Order numbers 1, 2, 14, and 14-A issued in 1986. So the Supreme Court held that public officials occupying positions classified as salary grade 27 or higher are mentioned only in subsection 4A and subsection 4B, signifying the plain legislative intent of limiting the qualifying clause to such public officials. To include within the ambit of the qualifying clause the persons covered by subsection 4C would contravene the exclusive mandate of the PCGG to bring the civil and criminal cases pursuant to and in connection with EO numbers 1, 2, 14, and 14-A. So in view of this, the Sandiganbayan properly took cognizance of criminal case number 28001 and criminal case number 28002, despite Decini's being a private individual and despite the lack of any allegation of his being the co-principal, accomplice, or accessory of a public official in the commission of the offenses charged, because it falls under subsection 4C. Okay? Okay, take note again, let us see the difference. Subsection 4C provides for the crime civil and criminal cases filed pursuant to and in connection with EO 1, 2, 14, and 14A issued in 1986. Whereas another part of the law provides that in case private individuals are charged as co-principals, accomplices, or accessories to the public officers or employees, including those employed in government-owned or controlled corporations, they shall be tried jointly with said public officers and employees in the proper courts, which shall exercise exclusive jurisdiction over them. So, despite the latter provision of charging the private individual as co-principals, accomplices, or accessories, if this is not done, if they are not charged as co-principal, accomplice, or accessory, they can still fall under the jurisdiction of the Sandiganbayan if the crime committed falls under subsection 4C.